And so, Jeremy, witness testimony, it sounds like, is over. Was this the right call for Hunter Biden not to take the stand?
You know, absolutely. It's easy to say something after the fact, but it certainly was. You know, there's a line from the movie or documentary, The Alpinist, about a solo climber, and solo climbing is only for the best climber on their very best day. The same thing applies here. It's only for the best client, the best defendant on their very best day. And if you have something to add, and here, just to the point we just heard, what are you going to say? That I didn't use drugs on these days or these particular day when you have it on buttressing on one side and the other, and your own daughter just came out, whose sympathy and heartstrings, and was genuine, but she was impeached fairly well, that no, well, you know what, he may not have been on certain times, but on this day, you're still not giving me the right answer that I want. So I think it was the right move. Otherwise, he's exposing himself potentially to potential perjury charge, and maybe even losing that advantage of nullification if possible, or hanging a juror if possible, and you don't want to jeopardize that.
Catherine, the last witness to take the stand was Naomi Biden, Hunter's daughter, and she did testify that at the time around when this gun was purchased, that her father seemed hopeful and sober. Couple of key words there before he had submitted the gun application. Based on what we heard during this trial and the three witnesses who testified on behalf of the defense, did they provide reasonable doubt?
Well, the defense hopes so. And I have a different view of the cross-examination of his daughter. When I was a prosecutor, you had family members routinely, the mother, the child, testify on behalf of the defendant. And if they weren't involved in the criminal activity, I was very gentle with them, because the jury knows why they're there, because they love their father, they love their husband. And so I would just limit it to, you weren't there on October 12, 2018, when your father filled out this application, correct? You don't know whether or not on that day he was using drugs, correct? And sit down. I thought, and this is my personal opinion, the prosecutor's a little too nasty to her, you know, trying to make it seem he's really not that good a father. He's, you know, texting you in the middle of the night. And I thought that went overboard, because...
And that could work against the prosecution?
It could. You know, it's not the own that the prosecutors think it is. And all the defense has here is reasonable doubt, that on that day, they want the jury to know, think of it literally, he was not using drugs. And in his head, as a recovering addict, he wasn't addicted to drugs on that day.
As we look toward jury instructions, Ken, Hunter Biden's team had asked for some specifics and tweaks to be made, and for the judge to say certain things in one particular section. What do we know about where the judge landed on this issue and what we can expect that the jurors will hear?
Those negotiations are still ongoing. I just want to clear one thing up. The prosecution doesn't have to prove in this case that he used drugs on the day he purchased the gun. That's explicitly not the case, and it's in the jury instructions. They just have to show that he was a drug user at the time or addicted to drugs, and at the time is loosely defined in the law. In terms of the jury instruction, though, what Hunter Biden's lawyers were trying to insert, and I don't believe they were successful, but we haven't gotten the final word, is the theory of the defense that Mr. Biden didn't knowingly lie on that form, and that what was in his own mind was very important. Even if the evidence suggested to other people he was a drug user, if he didn't consider himself a drug user, that was instrumental. The judge seemed to be leaning against including that in the jury instructions. We'll have to see at the end of the day how she decided.
And let me read to you, Jeremy, what the defense asked the judge to read to the jury in these instructions. Quote, Mr. Biden's response to the charges is that he never knowingly either possessed a gun when he thought of himself as a user of drugs or addicted to them, and he did not knowingly lie on a form that asked him, are you a user or addict? Because he did not believe he was either a drug user or addict at the time. Now, Judge Noriega called this an argument. She said she didn't think it was appropriate for her to say this. Do you agree?
I agree. It seems as if you're adding in issues of fact that are up for debate. That's the whole argument here between the prosecution and the defense. Was he knowingly doing so? Did he actually use these drugs before or after? And what we just heard before, it didn't have to use it on that day, but it's certainly relevant to the inquiry as to when the last time he was using drugs, and you can corroborate that, and then when he started again, if you believe he stopped. So this is more of an issue of fact. This is what you do. You marshal the evidence in your closing, and you say, this is why you should believe a particular reason or a particular set of theories. That is not what you do with the jury instruction. So I do agree with her.
Catherine, is there anything specific you think either the defense or the prosecution needs to clear up in their closing arguments?
All the defense has is what they want the judge to instruct the jury on, which they're not going to.
So that's what they'll say, right?
He was in recovery. He didn't believe, there was no intent on his part to do that. The prosecution has, here's the book, here's his voice. He was an addict. He said he was. So it's they are saying, the prosecutor, proof beyond a reasonable doubt. The defense is saying, and realistically, it is true. When you're in recovery, you take one day at a time. And so if the jury believes that on behalf of the defense, then there's the reasonable doubt.
The jury foreperson, we know, has a sister who has struggled with addiction, alcohol and drugs, is my understanding. How do you expect this component to sit with the jury?
I think that's something that absolutely Lowell has to weave into this narrative, into this story. There's a human element here. It's not just proof beyond a reasonable doubt. Certainly when you look at the evidence and the facts, that's what you have to argue, because there's no nullification per se, but the elements of the crime are the elements of the crime, but you want to play to the heartstrings. And I think if I recall correctly, when Lowell opened, he mentioned, I'm an AA, I'm an addict, and you're an addict forever, even if you're not using. What does that mean? It's constitutionally vague, which is another argument. But if I can get you as a juror to feel my pain and understand that people suffer and they shouldn't be punished for suffering, and he had that firearm for 11 days, then you throw in the elements of knowing and an addiction, then maybe you can get that nullification, because this is not like Donald Trump, where you're going to get someone to say, oh, my God, I feel such compassion for falsifying business records. I remember when I knew someone who falsified a record. This is so different. It's a different animal. And you have to add that element into your summation as a defense.